I'm Kuljit Bhogal KC. I'm a public law barrister at Cornerstone Barristers, and I co-head the housing team here. I'm going to be speaking today along with India Flanagan and Sarah Salmon, also members of the public law and housing teams here in Chambers. Just to tell you a bit about myself, I practice in all areas of public law, but have a particular interest in the management of public spaces and in housing more generally, as well as court of protection work. And specifically in relation to injunctions, that being the topic we're going to be talking about today, I was involved in the Super Saturday injunction, which was the injunction that related to the first Saturday after the lockdown restrictions were lifted, those being the restrictions that only allowed us out for an hour a day. And a local authority applied for an injunction to a persons unknown injunction under Section 222 of the Local Government Act of 1972 to regulate the way in which some of its open spaces were going to be used for fear of the behaviour that might occur with the pubs reopening and people being out and about in the sunny weather, as well as a number of other ways in which court of injunctions have been used in relation to different behaviour. I'm going to be inviting attendees who are on this webinar to put any questions that they have in the Q&A function that you can see on your screens. We've also had a number of questions sent in to us in advance that we're going to endeavour to answer as we go along, with the view to saving some time at the end to answer any questions that you do put in the Q&A. I will say that we're going to try and answer any questions that are of more general application. It's always difficult to give specific advice about specific cases in an environment such as this. But if there are cases that are questions of general application, we'll do our best to deal with those. And as I say, the webinar is being recorded. You'll be able to watch it back at your leisure. And the slides that we've produced are also going to be shared with you. There are a large number of slides, and I will say that we aren't going to be speaking to every one of them, but you will have the information available to you after today's session. So as I say, I'm speaking with two other members of the public law and housing teams. Sarah Salmon, her work has included cases involving Section 222 of the Local Government Act of 1972, fraud investigations, duties owed to children, discrimination claims, gypsy and traveller claims. And in addition to her local government and public law practice, Sarah has got experience of dealing with Equality Act and human rights issues on a regular basis. She's also been involved more recently in advising Welsh authorities and Welsh registered providers in relation to Renting Homes Wales Act, and has considerable experience of the issues that are being faced in Wales in relation to those providers. India Flanagan joined Chambers last year, and she is one of the more junior members of our team, but practices predominantly in court of protection and housing. She's got recent experience of dealing with cases involving injunctions, both in the context of antisocial behaviour, but also in the context of court of protection cases in the High Court. And she's previously practiced at a Chambers where she was doing more family work, and so has experience of cases concerning injunctions relating to non-molestation and occupation under the Family Law Act of 1996, and she'll be sharing some of that experience with us today. I should also say before we get going that if you don't already subscribe to our e-flashes, you can do that on our Chambers website. We do publish a newsletter that Sarah co-authors along with Tara O'Leary, and it is worth signing up if you want to get updates in this field, as well as keeping a record of all our webinars and previous events and forthcoming events. Our website's got a wealth of information on all of those things. So with that introduction, I'm going to move on to consider to tell you a bit about what we're going to cover. And if I could ask Will to move the slides on, please, to slide 3. So we're going to look at the various ways in which injunctions can be used. And I should say early on that this webinar is not going to be a webinar about how you apply for a Section 1 injunction. So if that's what you tuned in to listen to, I'm sorry to disappoint you, but there are other resources on our website that will provide you with that assistance. And those are things that you can read about and find out about elsewhere. Really, what we want to do with this webinar is add some value to how these injunctions in different forms can be used, the various behaviours that they can be used for, and then some of the general principles that apply across the board, regardless of the legislation that you're relying on and some of the challenges that you'll face applying for these. So although we're focusing on injunctions, it is worth mentioning that when looking at the enforcement power that you might want to apply in your case, you need to have an eye to the full suite of powers that are available to you. And that includes other measures to deal with individual behaviour. They might be CPNs or warning letters and other sort of non-enforcement type options, as well as some of the options that attach to the space or the property. So it might be a closure order or a public spaces protection order, as well as looking at some of the criminal remedies that are available to you. And the three of us have got experience in advising across all of those, should you need assistance on those. And in covering the various ways in which injunctions can be used and the various behaviours, we're also going to be looking at some of the common errors that we've come across in the way in which these applications have been made and things to be mindful of. So with that in mind, I'm going to turn to looking at the various legislative powers that are available. And on slide 5 is a list of some of the legislation and some of the behaviours that can be used to, can be targeted in relation to injunctive powers. We're going to be touching on all of these, with some of these topics being gone into in a bit more detail than others. And with that in mind, I'm going to move first of all to injunctions under the 2014 Act. And on the next slide, there is reference to both the Antisocial Behaviour, Crime and Policing Act of 2014, which many of you will be familiar with. And you'll know that I'm not going to read the slide, but I want to draw out a few points in relation to Section 1 applications. And they are that no doubt you're already aware that the behaviour doesn't already have to have occurred. So if one looks at the definition of antisocial behaviour in Section 2, what that reads is conduct that's caused or is likely to cause harassment, alarm or distress, or conduct which is capable of causing a nuisance or annoyance, in the two different contexts that are set out there. So the point to make is that the behaviour doesn't have to have occurred. It can be actual or apprehended behaviour that you're seeking to regulate. And what that leads into is the type of evidence that you might rely on in an application under Section 1. And that means you can rely on hearsay evidence. You can rely on officer evidence where that's appropriate and where you don't have direct evidence, because you can bring that within the likely to cause limb or the capable of causing limb of the test. And so it's worth bearing that in mind. Later, we're going to address evidence and the best evidence, but there will be cases where you might not have a direct witness that's prepared to be named in witness evidence, and you need to think about other ways in which you can introduce that evidence. And the test itself lends itself to hearsay evidence being introduced in appropriate cases. On the right-hand side of the slide, you've got the Policing and Crime Act 2009, and this is the legislation that you would use if you were applying for a gang injunction in respect of group behaviour. And I've had the privilege of leading Sarah and Jack Barber in chambers on an application involving two rival gangs recently. I think it was last year that we did a 3-week trial in relation to that application. And very often these applications are they are more challenging, and they're more challenging to put before the court because of the need to establish gang-related violence or gang-related drug dealing activity. And that gang connection can sometimes be difficult to establish. And that's why in some cases it's going to be appropriate to make an application for a gang injunction alongside a 2014 Act injunction, where you don't have that additional hurdle of having to establish a gang connection. So it's worth bearing that in mind. That gang connection can take various forms, and the case that Sarah and I were involved in was effectively a postcode gang. But I've been involved in a gang which called itself the Green Gang because it wore green clothing. That was what it was known for. And then also a gang in South London that called themselves the Shower Chick Girls. They were far from cute and fluffy, but were involved in a lot of knife crime and other behaviour that was terrorising the neighbourhood where they operated. And so it's worth bearing in mind that you need to look very carefully at the kind of evidence you've got for your gang connection. And if you don't have that gang connection, or you're concerned about whether it's going to be enough, think about whether you want to apply for a 2009 Act injunction alongside a Section 1 injunction. So on the next slide, we've got further injunctive relief in relation to behaviour. And here we've got the Protection from Harassment Act of 1997. And as you'll know, this takes two forms. There's the criminal offence that it creates that will be investigated by the police, and then the CPS would make a decision about prosecuting. And then you have the ability to make an application for an injunction as a civil remedy, which is found in Section 3A. And you need to meet the test set out in Section 1A, which is on those slides. There's no definition of harassment within this piece of legislation, but there is some case law, and I'm going to just bring up an advice I've recently worked on, just to draw out some of the principles. It was a case called Madrowski and Guy's and St Thomas's NHS Trust from 2007, where Baroness Hale made some observations in relation to what harassment means. And what she said was that there needs to, the decision making is left to the court, and for the court to exercise its wisdom and to draw sensible lines between ordinary banter and badinage of life and the genuinely offensive and unacceptable types of behaviour. And so there's a certain de minimis that needs to be reached before harassment is going to be established under these provisions. And Lord Nichols went on to say at paragraph 30 of that judgment that the courts are well able to recognise the boundary between conduct which is unattractive, even unreasonable, and conduct which is oppressive and unacceptable. And to cross the boundary from regrettable to the unacceptable, the gravity of the misconduct must be of an order which would sustain criminal liability under Section 2. And that's really the point I wanted to draw out about these provisions. Many of you will be from local authorities or from registered providers where you have the ability to rely on the 2014 Act. But if you are in the position of representing a body that doesn't have the advantage of that, and the obvious is an NHS trust that doesn't fall within the definitions in Section 5 of the 2014 Act, for example, then there is this legislation that you can consider and whether it's appropriate for use in your case. On the next slide, we've got a further provision in relation to behaviour. Will, I could ask you, thank you. Section 222 of the Local Government Act of 1972, many of you will be familiar with this provision, and Sarah's going to be talking about it in more detail. But what this provision can do is be directed at both individuals and unnamed defendants. I won't say any more because Sarah's going to be covering that in some more detail. Over the page on the next slide, we have defamation claims, and you've got there some information in relation to the basis upon which injunctions for defamation can be sought. I thought this was an appropriate point at which just to flag one of the issues that's come up frequently in some of the cases that I've been involved in, and that is that when you are looking at what people have done and said, and whether that's in written form or whether that's on social media, one of the considerations that you have to make as a public body, and that the court will take into account as a public authority under the Human Rights Act of 1998, is that restricting what someone says and does can be a breach of their Article 10 rights to free speech. It might also impact on their Article 11 rights, but Article 10 is very often engaged, And one of the things that you'll need to be mindful of when you make applications is to ask yourselves whether there is an impact on Article 10 rights, and if there is an impact on Article 10 rights, to undertake an equality impact assessment or a human rights assessment to consider whether or not it's proportionate and justified to interfere with those rights. And you'll know that the case law suggests that when it comes to free speech, true free speech is said to be the kind of free speech that can have the impact of shocking or offending or disturbing somebody. So just because somebody's offended doesn't mean that they should then be that speech should be curtailed. And it was the well-known case of Handyside that set down that proposition, and that it still holds true. You do have to be very careful about ensuring that you don't act in a way that restricts rights, in a way that's disproportionate or not justified. And sometimes thinking about what's justified and proportionate means looking at the other options, the other lesser intrusive options that there might be before you turn to looking at an injunction application. Over the page on the next slide, we've got freezing injunctions. I'm not going to tell you too much about these. You've got some information on the slides. And I'm going to hand over to Sarah, who's going to take us through section 222 injunctions.
Thank you, Kuljit. So we saw from Kuljit's talk earlier that a local, sorry, I don't know how to turn that off. We saw in Kuljit's slides earlier that a local authority has the power to defend or prosecute legal proceedings under section 222 of the Local Government Act 1972. Those powers that have been created by section 222 reflect those that were available to the Attorney General prior to the enactment of section 222. And they include a power of a local authority to seek injunction relief in its own name and without reference to the Attorney General in support of the criminal law and to prevent a public nuisance. On this slide, though, there are some important things that I want to stress about the power. So first of all, it is an additional power. So local authorities are, of course, creatures of statute and will find themselves to have powers set out in a number of other legislative schemes, many of which in relation to injunctions, Kuljit's just gone through, and India will be going through some more. Secondly, the power does have its limitations. So it is a condition of the use of the powers created by section 222 that the authority must consider it expedient to do so for the promotion or protection of those in their area. And just to be clear, that means inhabitants generally, rather than a particular section of them. But and in the Stoke-on-Trent case, which is cited on the slide, it was said that it's in everyone's interest, and particularly so in urban areas, that a local authority should do what it can within its powers to establish and maintain an ambience of a law-abiding community. And what should be done for this purpose is for the local authority to decide. And that brings me on to the third point I want to stress, is that it is for the local authority to decide what it's in its area's interest. So it's not for the court. Finally, on this slide, there's a few examples, and I'm going to come to the examples in more detail a bit later on. But these examples set out there demonstrate the range of behaviour and issues that section 222 has been used for. So moving on to slide 12. Before the Bloomsbury case, which is set out on your slides, the courts have recognised the jurisdiction to make injunctions against all of the world, so that it's binding on every individual who has notice of the order, regardless of whether they are named as a party. And that was in a case where an order was needed so as to prevent the publication of information that was likely to endanger particular vulnerable claimants. And that was the case of Venables and Thompson. Delegates will notice their names against the news group Newspaper Limited. Bloomsbury was a case about unpublished copies of Harry Potter, which had been taken without authority and offered to the press by an unknown person or persons. And since Bloomsbury, injunctive relief, both interim relief and final relief, has been granted against persons unknown in numerous contexts, including protesters, trespassers, those behaving antisocially. The jurisdictions even extended further to worldwide freezing injunctions and proprietary injunctions in relation to Bitcoin, where there's been cyber attacks. So that demonstrates the extent to which the courts have been satisfied that it can grant injunctions against persons unknown. And moving on to slide 13, it is important, in my view, and I'm sure in a lot of people's views who have to apply for injunctions, to have the ability to seek injunctive relief against persons unknown. First of all, the remedy can be both preventative and anticipatory. So, as Kuljit was talking about in relation to Part 1 of the 2014 Act, you don't necessarily have to wait for the behaviour to have happened or whatever you're trying to prevent having happened. You can anticipate a threatened infringement of a public right by being able to apply for injunctions against persons unknown. And you'll see the comments at the second bullet point on the slides, and the court appear to have agreed that those types of objectives are commendable. And I've set out the quote there, so I don't propose to read it out. With section 222, however, and this comes to the third bullet point, practitioners need to be cautious if there are potential alternative remedies. So there was a case some time ago now, and in fact, I was involved in it when I was a pupil in Chambers, and it was a Birmingham City Council case against Shafi and Ellis. And that was a case that was dealing with tackling the problems of gangs in Birmingham prior to the 2009 Act. And the 2009 Act and the section on gangs in particular was brought in extremely quickly after Birmingham were unsuccessful in the case. And what that case said, when Birmingham was trying to use section 222 to deal with the gangs, was that really they had antisocial behaviour powers which were more suited, and they should look at using those. Now, of course, as I've mentioned, there is the power to seek a gang injunction. So I've just put one potential alternative remedy on the slide because it's one that will probably more likely than not come up when you're looking at section 222, and specifically where you're looking at section 222 against persons unknown, and that is a public space protection order under sections 59 to 75 of the 2014 Act. Now, they are intended to deal with a particular nuisance or a problem in a particular area that is detrimental to the local community's quality of life by imposing conditions on the use of that area that will apply to everybody. And they can operate against the world, they can criminalise activities, and they can be widely drawn, although, again, exercising caution, people need to be very careful when whatever injunctive relief or alternative remedy you're using, when you're looking at terms, you need to think about how they are drawn, because the courts are becoming, in my view, increasingly critical of such orders that are too widely drawn. But public space protection orders have been used to deal with a whole range of issues. For example, drinking zones, controlled drinking zones, dogs, and preventing street gambling. There was actually a question asked before the webinar about the application of Wolverhampton City Council and Phelps, which was a case this year, and whether or not that could be applied to antisocial behaviour in communal areas such as drug activity. Now, that case was committal proceeding based on a car cruising injunction. So it was Section 222 injunction against, I think, named people and persons unknown. And really, it's not going to help, probably, whoever asked that question. It may be worth a try, but it is really going to depend on the circumstances of the case. And when you are bringing a case like that, if you do have any named defendants, then my view is that you might want to plead the case differently for your named defendants and your unnamed defendants, because it may be, or probably likely, that you would have the ability potentially to seek an injunction under Part 1 of the 2014 Act if you have named defendants, but it could be a two-pronged approach within the same proceedings, or if you don't know the names of anybody, you could think about trying to use Section 222 to deal with that problem, but with very careful planning and very careful consideration of any other powers you might have available before you make that application. So moving on to slide 14. Now, this isn't about Section 222 in and of itself, but Section 187B of the Town and Country Planning Act is very often cited alongside Section 222 in applications. So in the Wolverhampton case against persons unknown, the Gypsy and Traveller case that ended up in the Supreme Court, I was actually counsel for a local authority who dropped out at after the High Court decision. But in that case, we had used Section 187B of the Town and Country Planning Act to sort of demonstrate why Section 222 would also be available, because what Section 187B gives the power of a local planning authority to do is seek an injunction against persons unknown. And the way all of those cases developed up until the Supreme Court was this idea that actually you couldn't get persons unknown injunctions in relation to Section 222. I think following Canada Goose, they were sort of called newcomer injunctions, but it was about those injunctions that were available against the world. And there is power in 189B of the Town and Country Planning Act, and you might find that that is something, especially if you're dealing with cases of encampments or people on your land, gypsies and travellers, that you might need to utilise as part of your Section 222 application. Moving on to slide 15, just drawing some more points out from the Town and Country Planning Act, the provisions confer the jurisdiction on both the High Court and the County Court to restrain breaches of planning control by injunction. And there's a couple of cases there which demonstrate when such injunctions have been granted. And you will see that the first one there is persons unknown. Just on the City of London case, that was an injunction for the removal of tents that had been put up by protesters near St Paul's Cathedral on the ground that no planning permission had been applied for in respect of a change of use. It was the fourth defendant in that case that was persons unknown. So although it's just Sam a day on the slide, it did involve persons unknown that had been taking part in the protest. So moving on to slide 16, which comes back to other examples where both Section 222 or other statutory powers have been used to obtain or attempt to obtain injunctions against persons unknown. So I've listed quite a few there. Now, I'm sure everyone on the talk, and I've already mentioned it, will be aware of how they've been used in terms of car or street cruising. And just to note there, Section 130 of the Highways Act of 1990 was also used in the Birmingham City Council case, albeit to a lesser extent than Section 222, to make those cases out. There's a Wandsworth, the second one on there is Wandsworth, and you'll see it was used for amplified music events or to deposit waste at communal area on a housing estate. So that goes back to the previous question about the Wolverhampton case about ASB in communal areas potentially. So these are all the things that you can have a look at to see whether or not Section 222 would be relevant to a case that you are contemplating bringing. There's been gathering for the purposes of organising, attending or participating in gatherings which may involve playing of amplified music. That's the Hackney case there. They've also been used for the felling of trees, and they've been used in conjunction in those cases with Section 41 of the Highways Act 1980, the Road Traffic Regulations Act 1984 as well, which essentially empowers a highway authority to restrict or prohibit temporarily the use of the road by members of the public. And in addition, I think there was also trespass mentioned in that case. So all of these types of issues and powers really do work together in relation to Section 222 and any applications. The school protester cases are on there. Now, in that case, interim injunctions were made against persons unknown under Section 222, Section 30 of the Highways Act 1980 and Section 1 of the Localism Act 2011. But final orders were refused in that case on the basis it was inappropriate to make a final injunction against persons unknown restricting protests outside a primary school, as the category was not readily identifiable. It concerned all persons other than the named defendants, and there was no limitation on the category. So this comes back to some of my points on caution, that again, if you're going against persons unknown, you should be thinking about the category of people as well that you're going against, because it just makes for a much stronger application that the court is more likely to want to entertain and want to give you relief on. And then finally, there's the begging case, unreported case back in 2015, which was begging in Leeds city centre. Now, once an injunction was made in that case, an application was made to set it aside on behalf of Mr. Scott, because he found himself facing committal proceedings for breach of the injunction, and Leeds City Council actually conceded that application. So that's how that case ended. I know the Swindon case is going to be discussed later, so I am going to leave it there and hand over, I think, to India.
Thanks, Sarah. I'm now going to talk about an injunction which is known as a breach of tenancy injunction. I mean, that's the technical word for it, but it's commonly referred, and I'm sure you're all familiar, to a gas access injunction. In our view, it's really important, however, to remember that really this is a breach of tenancy injunction to provide access when a tenant has breached their tenancy agreement and they have not allowed access. And whilst, of course, this type of injunction can serve as a very useful tool to allow landlords to access the property, to carry out and undertake compulsory gas safety checks, landlords need to always remember that they can utilise this type of injunction to gain access for other scenarios. So common examples include building safety works, fire stop works, and electrical checks. When making this application for this type of injunction, however, in our experience, we do advise caution on two main aspects. One, these applications are often routine, and often in our experience, a clause that is often sought is for a forced entry. When making this application, however, you need to always remember and check, is this specific clause of forced entry provided for in the tenancy agreement? Because in our view, in our experience, if it's not included in the tenancy agreement, our experience is that judges can often be reluctant to exercise their discretion and include that term as part of an interim or a final injunction. So the best practice going forward really is to ensure that if this provision is sought at the very early stages of the tenancy agreement, that clause needs to be included. And also in terms of the duration, it's often sought for injunctions to last the length of the tenancy agreement. And again, for clear reasons of proportionality, this is often not granted. And judges tend to, of course, it depends on the specific circumstances of each case, but judges will often grant an injunction to last the duration for at least one overdue inspection and one further inspection. So if we're going to turn over, Will, if you can, thank you. I'm now just going to briefly summarise or outline the principles in two other jurisdictions. The first is Court of Protection and the second is family. And it's very important, in my view, to remember that, of course, injunctions can be sought in a range of jurisdictions. And in this context, the Court of Protection. And there may be cases which you have, particularly possession cases, which concern defendants who lack capacity. They have parallel proceedings or ongoing proceedings for hoarding in the Court of Protection. And just to outline that the law is set out in this slide, but the Court of Protection can grant an injunction by virtue of Section 47 of the Mental Capacity Act 2005. That gives the COP the same powers as the High Court by virtue of Section 37 of the Senior Courts Act 1981. And Section 16(5) of the MCA permits the court to make further orders as it thinks it's necessary or expedient to give effect to. In terms of the enforcement of orders, similar rules and provisions as in the CPR apply to the COP. So in the COP rules and accompanying practice directions, they set out particularly Part 21 about enforcement of injunctions. And essentially the test, which is very clear in other jurisdictions, apply here, which is it just and convenient to grant an injunction? And just for context, in this context of COP, there's really two key considerations. Does P have an interest that merits protection? And is there a legal or equitable principle that justifies the making of an order? And in our experience, we tend to find that an injunction can be granted if it gives effect to a court's best interest decision as it's known. So in the COP, you can have injunctions for a range of different reasons. Examples could include an injunction to regulate, prohibit contact, to prohibit certain individuals from making arrangements concerning P from being removed from the jurisdiction or being married, and also sometimes in certain appropriate circumstances compelling a party's engagement with another party, such as a public body. But again, the key principle that is outlined in COP is in a case set out in the last bullet point. Her Honour Senior Judge Hilda considered that the Court of Protection's powers of injunctive relief are limited, and therefore they're only used in connection with its jurisdiction when it's necessary and expedient to do so. So just turning over to the family jurisdiction, I'm not going to go into detail on this. The key principles for some of the orders that can be sort of summarised on this slide. The two key injunctions in family law are a non-molestation order and an occupation order, as Kuljit already outlined. Both are provided for in the Family Law Act 1996. But why we have included this slide is because it's useful to consider the principles which are set out in the Family Law Act, as they're often referred to in the context of injunctions for other proceedings. So for example, in the Court of Appeal judgment in Moat Housing Group, South Limited and Harris and Heartless, in the context of a without notice application for an ASB injunction, Lord Justice Brooke provided that judges in the county courts should follow the guidance which is set out in Section 45 of the Family Law Act, which sets out principles for without notice, which we will be discussing in due course. So I'm now going to hand back over, Willis, to the next slide, to lessons learned from the case law. Thank you.
In this section of the talk, I'm going to speak to two cases that are relatively recent in this context. And before handing back to India, who's going to be looking at some general considerations which apply in relation to applications for injunctions. So on the next slide is the first case I'm going to talk about. Sarah's already mentioned it. It's the Wolverhampton case involving gypsies and travellers. And by the time it reached the Supreme Court, there were 15 local authorities left still involved, but I think there was something like over 30 involved at one point. And essentially the background to this claim was the use of various pieces of legislation to tackle not just gypsies and travellers, but car cruising and other issues. But the large majority were gypsy and traveller cases. And they'd used Section 222 of the Local Government Act 72. They'd used Section 187B, excuse me, of the Planning Act of 1990. There was some reliance on Section 130 of the Highways Act, and also Section 1 of the 2014 Act in respect of named individuals. So there was a whole raft of legislative provisions that were considered, and I've only named some of them. And I'm not going to, essentially where we've got to in a brief bullet point is that, yes, you can have persons unknown injunctions. So this whole concept of newcomer injunctions and can you, can't you, has finally been resolved by the Supreme Court. So I'm going to leave you to look at some of the detail, mindful of the time, on how one makes those applications. They aren't straightforward. One needs to have careful thought to your evidence and how you define the persons unknown you're going against. You need to give careful thought to service and issues of those type. But I'm just going to flag the need for compelling justification. If we could just go back to that slide for a second, Will, thank you. In paragraph 188, what the court have said, and this is just answering one of the questions that was sent to us in advance of the webinar, the court has said that in order to make an application against persons unknown, you need to have compelling justification, which you demonstrate by way of detailed evidence. And the reason I want to pick up on this is that it touches on some of the other types of injunctions that are made, but also other types of orders that are made. So also, for example, public spaces protection orders, which is something that I do a lot of work in. I've been involved in all of the challenges that have been before the court to date. And it's a way of the court wanting to know whether you really need this injunction or this PSPO, or are there other less intrusive measures that you could use to achieve the same or similar outcome? So in my view, what compelling justification means is a local authority or applicant showing to the court, demonstrating by way of evidence that what it's working out is, and it's what I might say to my children when they're doing their maths homework, you need to tell the teacher how you've got to this answer. And I think it's the same when it comes to this aspect of applying for injunctions, is that you need to show the judge how you've decided that an injunction is appropriate as opposed to other remedies. And that means demonstrating that you've given consideration to the other options that there might be, whether they're civil or criminal. And it doesn't mean that you have to have utilised them, but it means that you have to have thought about them and given some consideration to either using them or explaining why they're not appropriate. And that's an area where many clients fall down in relation to the compelling justification and just the proportionality of their applications. And I wanted to flag that about this case. On the next slide, we've got the case of Swindon Borough Council and Aybrook. It was decided, I think, on the 8th of March of this year, so very much hot off the press. It's a case which was about aggressive begging and the breach of an injunction that had been granted for aggressive begging. It had been to the court several times, and I think on the 5th or 6th occasion when it went to court, the judge that heard the application for breach said, actually, no, I don't think this injunction should have been granted, and queried this reference to aggressive begging, which had found its way into the restrictions for the injunction. And what the Court of Appeal said in this case was that it wasn't helpful to draw a distinction between aggressive begging and passive begging, because actually what this was a Section 1 2014 Act application, and what Section 1 required is evidence of harassment, alarm or distress. So this wasn't in the housing context, it was and so the higher threshold applied, harassment, alarm or distress. And so that's the question that the court should be asking itself, not labelling something as aggressive or passive begging, but does it meet the test, and does the evidence meet the test? So I just wanted to flag that in relation to this piece of this case, because of course begging is something that is a problem nationwide, and there have been various attempts to deal with it in various different ways. It's also worth noting there, and India's going to be dealing with this in a bit more detail, that the power of arrest shouldn't be dealt with shouldn't be attached just as a matter of course. Before I move on, just to flag that there are some proposals to scrap the provisions in the Vagrancy Act about begging and to introduce new provisions to deal with begging. Again, it's in the Criminal Justice Act. It's at report stage, so they may take a different form by the time they actually come to be enacted, or they might be ditched altogether. We don't yet know. But there is also a suggestion that in addition to scrapping those provisions, that enforcement that's targeted at begging doesn't have an inadvertent impact on targeting the homeless, who are recognised to be a vulnerable group. So there's a lot to think about when one's looking at enforcement in relation to begging or tents or paraphernalia that's associated with living on the streets. So with those matters in mind, I'm going to hand over to India, who's going to start us off with some general considerations when applying for an injunction.
Thanks very much, Kuljit. So as Kuljit's just explained, I'm going to talk about what you should consider when making an application, and this will cover applications supporting evidence, service, and Kuljit will then be speaking about considerations including about capacity and the public sector equality duty. So just going over to the next slide, which is about applications. As I'm sure lots of these bullet points will of course be very familiar to you, but applications should be made on at least 2 days notice to the respondent, except really for applications of course which are made without notice, and if the court has permitted a shorter period for the notice. When making an application, it's really important that you attach certain key documents. So a draft order, good practice is to use Form N16. And if you are seeking a power of arrest, you should also attach Form N110A. You should also attach a witness statement, which I will be talking about in the next slide. But in this application, you should set out in separate numbered paragraphs what terms of the injunction, are they prohibitions, are they positive requirements that you're seeking, and again separately set out each provision where it is sought for a power of arrest. Essentially, you need to make your application very, very clear. You don't want the judge to be trying to guess or think, well, what are you actually seeking? You just want it to be clearly set out on the page, which will make the judge's life much simpler. In terms of a draft order, whether or not you use Form N16, you need to check that it's vitally important that the order contains a penal notice, because of course that would be vital for any future application in respect of contempt of court proceedings. And set out here, of course, the definition for a penal notice is defined in the Civil Procedure Rules 81.2, which is a prominent notice on the front of an order, warning of the consequences of any breach. So if we move over to the next slide, which is part 1 of 2, sounds very exciting, for witness statements. So all applications need to include a witness statement, which I've set out here what terms should be included in the witness statement. So for example, as I've already alluded to, your whole application needs to be very clear. So what terms are you applying for? Why are you applying for these terms? So for example, if you're applying for an exclusion zone, you need to set out why the size of the zone is proportionate. you should exhibit a clear map marking it out. You need to make sure that that map is very clear, both to the reader, but also crucially to the respondent, because a judge will be very unlikely to grant an exclusion zone if it's not proportionate to do so, but also if it's not clear enough for the respondent to be able to comply with. It's absolutely critical that if you are making a without notice application, and I have got a separate slide dealing with without notice, but if you are making a without notice application, you need to set out in the witness statement why notice has not been given, why it's necessary, and why it fulfills the relevant test. And the same consideration needs to be given for a power of arrest. Judges will need to see that evidence to consider if it is just and convenient and necessary and proportionate to impose those requirements. I think it is also good practice to explain what steps have been taken to address the antisocial behaviour. So, for example, if you've sent multiple warning letters to the respondent, those should be exhibited. Any relevant reactions the respondent has had or communication in response should also be set out. And similarly, and Kuljit will be talking about this in more detail, but any relevant information regarding the respondent's engagement with social services, and including consideration of if the respondent is vulnerable, there needs to be an analysis of why the application is necessary and proportionate and what individuals or bodies have been consulted. I will be explaining in the next slide other details that should be included, but it's very important to remember, particularly for a without notice first hearing, judges are extremely unlikely, in my experience, to hear any oral evidence, and therefore that is why it's crucial to include the key details in your witness statement and in your exhibits. Of course, you should always remember the useful tool of seeking permission at a first hearing when setting trial directions to file and serve an updating witness statement, which can address any incidents post-application, because that may very well be necessary and relevant to any considerations the judge has for reasonableness and whether or not it's just and convenient to impose an injunction. So we move over to the next slide, thank you, Will, to part of what you should actually include in the witness statement. And I know the phrase less is more can often work wonders, but it's important, I think, in the context of this type of witness statement, that less is not always more, and actually detail can be your friend in this case. And as I've already set out, the judges are unlikely to hear oral evidence, and therefore it's crucial that you have all of the information you want the judge to consider in your witness statement. It shouldn't be a guessing game of why is this application being made without notice. So here it's set out, I won't go through all of them, but just to highlight the detail of allegations is absolutely vital. And it does sound very basic, but it should have clear descriptions and explanations from the relevant witnesses who can give direct evidence of where the allegations happened, when they did, what happened, why, and any other relevant consideration about the respondent's reaction. Witness statements from direct witnesses to the incidents, witness statements from third parties. So if the incident has been reported and they can exhibit a relevant email or report, that would also be useful. And the same is for contemporaneous records. So often in my experience, I find that witness statements will say, well, I've emailed to report the incident, but then those emails are not exhibited, and they should be. And the same for warning letters. Really crucial bit of evidence is video footage and audio recordings. If you have a witness statement that says, I have CCTV of this incident, or I have a recording or an audio, and it's not exhibited, well, the judge will very likely say, well, why is that not the case? And it really should be. And the same for certificate of convictions. If you are able to get a certificate of conviction or a police incident report that you've reported to the police, you should also exhibit that as well. So now I'm going to speak very briefly about a schedule of allegations. I think there's two key points to highlight. It can be very effective if the schedule is used correctly. However, we do need to advise caution that really whether or not a schedule is suitable for a particular case depends on that case circumstances. Sometimes in our experience, that there is a risk that the judge may not allow you to introduce evidence beyond the schedule and essentially treat it like a pleading. A schedule is not supposed to be a pleading. A schedule is really there to police the number of allegations and to ensure proportionality. And obviously that can be very useful for time estimates. If a judge has only got a day to deal with an ASB trial or an injunction, then they would only be able to consider approximately a short 5 or up to 10 allegations, and therefore if a judge is being asked to deal with a significant higher number, then the judge will want a schedule to consider proportionality. But always remember that you should be exhibiting a narrative statement that essentially sets out the context, because again, that is relevant to considerations of reasonableness and proportionality of whether or not an injunction should be granted. I move on now, next slide please, to service. This is, of course, an absolutely crucial component of any successful application. In good time prior to the hearing and prior to the first hearing, whether or not that's an access injunction or an ASB or injunction or any other of the other injunctions we've spoken about, check that all relevant documents have been served, of course, for on-notice applications. In my experience, I've had cases where you've had a certificate of service which has served, for example, a notice of hearing, but it doesn't actually serve the key documents, and therefore we've had to seek adjournments in those circumstances. So to ensure that doesn't arise, in good time, get a certificate of service from the process server and check all relevant documents so application papers have been served. Service of the order is, following an order being made, is imperative. It is of no effect unless that personal service has been effective or that the court has dispensed with service. You can dispense with service for prohibitory orders and when the court is satisfied that the respondents had notice. So for example, if the respondent is in attendance at the hearing, but you can't dispense with service for orders which include positive requirements. In our view, it is very good practice to ask the judge for a approved or sealed copy if possible, but certainly an approved copy of the order be given to the respondent at the end of the hearing. Why? Well, this has several benefits that are listed under the second bullet point. It removes the delay between an order being drawn up and being sealed and provided by the court office. Personal service can be dispensed with. But in order to give effect to all of those benefits, you need to clearly record in that order that it's been given to the respondent at the end of the hearing. Personal service has been dispensed with, the respondent attended at court. I also consider it's good practice to include recitals that just set it all out, that the judge explained the terms of the order, the implications of any breaches, and the respondent confirmed their understanding in the hearing. So if I move on to without notice.
India, I'm just going to jump in to say that I'm conscious that it's 11 o'clock and some of the attendees may need to depart if you've only allowed an hour for this webinar. We're going to continue for a short while. It is going to be recorded, and if you need to catch up, the recording will be made available in the next few days on the Chamber's website. But India, I think we should carry on for a short time and see how we get on.
Thanks, Kuljit. Yes, I will just summarise this very briefly, but as Kuljit said, the detail is also in the slides as well for your information. We did get a question about without notice, when's the best time to use a without notice application. This obviously depends on the circumstances, but in summary, when the behaviour is so serious that an immediate application is required, but it must be justified and there must be a proper basis which warrants that application. So the first bullet point here says it should not be made routinely and only in exceptional circumstances. And the case I've already referred to, the Court of Appeal case of Heartless, Lord Justice Brooke sets out guidance about how a without notice injunction should only be made if there is a very good reason. And I won't repeat the other quotations here because you've got them on the slide. So if I go to the next slide, please, Will. Already covered this to some detail, but thank you. If the respondent has been already warned that an application is imminent and there's been no detrimental behaviour that they've exhibited, no adverse consequences, then in that case, I think in our view, it would be difficult to justify a without notice application. So it goes back to the view that there needs to be a proper evidenced basis. And it's important to remember that, of course, injunctions can be made in the High Court or the County Court. Vast majority are in the County Court, but if in an appropriate and exceptional case, the High Court can be utilised for out of hours applications. Next slide, please. In terms of the power of arrest, well, again, there needs to be a clear basis, and I understand a question has been asked on proposed refilms under the Criminal Justice Bill. If we have sufficient time at the end, we will address that. But in terms of the basic summary, a power of arrest can be provided if there is a reasonable cause to believe that a breach of an injunction has occurred. It can be attached to a positive or a prohibitory requirement, but it can only be attached if the test under the 2014 Act is met, i.e. does the court consider that the ASB includes the use or threatened use of violence against other persons, or where it considers there is a significant risk of harm to other persons from the respondent. Just one point to highlight on this slide, that if a power of arrest is made and the court considers that that test under section 4.1 is met and it is made without notice, then applicants need to remember that a copy must first be given of the approved or sealed order to the respondent and the power of arrest form before a copy is given to the police station. And that is provided for in the rule CPR 65.44. Next slide, please. In terms of committal applications, given the time, I won't go through this in detail, but of course it's always important to remember the considerations whether or not to make an application under the first bullet point. And here we've just set out some guidance that's useful to remember about an actual committal hearing if you get to that stage. And remember, of course, these are serious proceedings and there is a heightened level of disclosure on the applicant. If I can move on to protected party, which Kuljit will be summarising now. Thank you.
Thank you very much, India. Just for those of you that might have missed it, we're going to carry, I know we're beyond the 11 o'clock time frame, but we're going to carry on for a short while. And if you do have to drop off, the recording will be available to you to look at at your leisure. And as India's mentioned, the slides are very detailed, and we've done that deliberately so that you've got something to look at after the event, and they'll be emailed to you. Just to pick up on something very briefly in relation to power of arrest, in relation to one of the questions that's been asked, it is right to say that there are some proposals afoot to suggest that powers of arrest should be available in respect of every limb of an injunction. Those proposals are found in the Criminal Justice Bill that's currently going through Parliament. It's at report stage at the moment, so they're not yet in force. They may take a different form, they may be ditched altogether, we simply don't know. But at this stage, certainly for section 1 injunctions, the provisions are found in section 4 as India's highlighted. And there are other measures where other power of arrest can be sought in other statutory contexts, should that be what you're applying under. I'm going to deal with protected parties next, and also have a brief look at understanding the Injunction and Equality Act issues. I'm mindful of the time, so I am going to whiz through a lot of this. But if there are questions arising, or if you need advice in relation to a specific case, then please get in touch with our clerks who'll be able to put you in touch with us. So protected parties, those are parties that lack litigation capacity. And if someone lacks litigation capacity to conduct the litigation, they will need what's called a litigation friend in order to conduct the litigation on their behalf. So if you're in the territory or making an application in respect to someone who lacks capacity, or you suspect you might be in the territory of making an application in respect to someone that lacks capacity, it's really important to have regard to what you can and can't do. And what CPR 21 says is that the only step that you're allowed to take is to issue the proceedings. You can't do anything more. You can't seek an interim order. You can't make any further progress other than issuing. And really what you ought to be doing prior to making your application, if you know or suspect that someone is a protected party, is that you must be making inquiries beforehand. So there might be red flags. If the type of behaviour is such that you think this person's not all there, you need to ask yourself, it may be that they have got litigation capacity but lack capacity in other domains. But if there are red flags because of the type of behaviour, then you should be making inquiries of your local CMHT teams to find out if they're known to them or if they have previously been known to them. And if they have been, whether there's any information that they're able to share with you. What you might find if you don't make those inquiries is that the judge is going to not allow you to do anything else until you've made those inquiries. And will likely ask you questions about capacity when it comes to the first hearing, at which you might find that the court orders that the official solicitor act if there isn't a suitable litigation friend appointed, and everything comes to a halt until the litigation friend is in situ. And that's why it's important, if you can, to front load those inquiries. On the next slide, I've set out that capacity is a domain-specific assessment. And what that means is that somebody might have the capacity to make a decision about what they want for breakfast, but they might not have a capacity to make a decision about where they want to live, or how they're going to instruct their solicitor in relation to legal proceedings. So it depends on the decision that you're looking at and whether somebody has capacity in relation to that specific decision. And there are professionals that can undertake capacity assessments. And then that's the sort of thing that you need to be thinking about if you think capacity might be an issue in your case. In terms of the next slide, I'm going to not spend too much time on this, but the sorts of information that the judge might want to know about are listed on this slide. And one of the things is this behaviour the defendant's choice? Are they exercising a choice to engage in this behaviour? Or is it a feature of a medical condition that they've got? And sometimes if it's a feature of a medical condition that they've got, then they don't have the choice and they don't have the ability to control their behaviour. And that's the distinction the judge is going to want to know about when it comes to the next slide, which talks about understanding the injunction. And you'll know that the leading case on this is Wookie, which says that there is inherent jurisdiction to grant an injunction in relation to mentally ill person, but you can't obtain an injunction if it can't be enforced. And it can't be enforced if that person lacks an understanding of what they are doing and whether they are a capability to understand the terms of the injunction, but also the ability to control their behaviour. And so it's about that distinction that's on that slide, the C versus F case of, is it a case of being incapable of complying, or is this about disobedience of an order? And that's where a judge is very likely to want to have some medical or other evidence to support any application that's being made for an injunction, to be satisfied that the person in respect of whom they're making the injunction has the ability to understand it. And it really flows from the basic concepts that if someone breaches an injunction, there are criminal consequences. And so someone is at risk of being imprisoned if they breach. And so the judge will want to know that they can understand the order, not just that they've been served with it, that they know about it, that they've been able to participate in the application, but also that fundamentally when an order is made, they're able to comply with it. And so that's why judges are mindful of making sure that they've got evidence of capacity, and that's where you can be helpful to a judge in terms of front loading your application and preempting some of the questions that might be asked. And on the next slide, there are some extracts from Wookie being applied in a case called PMP. And the highlighted section there just really underlines what I've said, that it's crucial that a litigant against whom an order is to be made understands what he must not do. And that the order on a piece of paper tells him he must not do A, B, and C, and that there's the penal notice. And believe it or not, I've had more than one case where there have been injunctions made where there has not been a penal notice. And I've come in and been asked to pick up the pieces. And so those basics, there is a merit in using the template forms, because at least template forms contain the penal notice. And moving on to the Equality Act, some of the issues we've talked about in relation to capacity touch on Equality Act issues, because of course somebody who lacks capacity may or may not, depend on the circumstances, but may also have a disability within the meaning of the Equality Act of 2010. And if they do have a disability within the meaning of the Act 2010, then that's again a decision that needs to be reached with the assistance of medical information. So an expert will be required to provide some evidence on somebody's disability. And in instructing that expert, you want to make sure that you have a hand in instructing that expert. Do not allow the other side to go away and instruct their own expert. Have a joint expert or have your own expert, because you want to make sure that you direct the expert as to the correct considerations under the Equality Act. And that's a sophisticated exercise in making sure that the correct factors are taken into account, and that the legal tests for finding the existence of a disability are considered in that expert's report. Public sector equality duty. This isn't something that's difficult to comply with, nor is it a tick box exercise. But what there is, we're finding in chambers that there is a trend towards raising public sector equality duty points, particularly when there's not a lot else to be said. And so where there isn't much to be said in someone's defence, PSED, Equality Act issues, human rights issues come to the fore, and are in vogue, if I can put it that way. And so be mindful of that and preempt that. And in your application documents, in your witness statements, show that you've had consideration to these things in advance of somebody saying, well, you didn't actually have full regard to your statutory obligations. On the next slide, we've flagged that there is an obligation on local authorities to assess a person who might require care and support. So if you're a local authority, be mindful of that and make the appropriate reference. But if you're not a local authority, be mindful of this obligation, because you can require your local authority or invite your local authority to make the relevant assessment and consider whether care and support needs to be put in place for them. And the reality is that in cases involving vulnerable people, and often we have vulnerable people on both sides, both victims and perpetrators can very often have vulnerabilities by the very nature of social housing and what social housing is. To be afforded social housing, very often there are needs that need to be met. You need to be mindful of those needs on both sides, and your perpetrator, problem solving in relation to your perpetrator is going to involve a multi-agency approach. And that might mean liaising, and should mean liaising with your police colleagues, with the CMHT, with social services, with leaving care services if they're relevant, and looking and seeing whether enforcement is the right option or whether you should be going down a different route. So that really brings us to the end of this seminar. On the last slide, we've got common errors, slide 41. We've dealt with a number of these during the course of this webinar, so I'm not going to say any more about them. And we've also been looking at answering some of the questions as we've gone along, both in written form and during what we've said in this webinar. And given that we've overrun, I'm not going to invite any more questions at this stage. What I am going to flag is what I've mentioned already, which is that there are changes proposed in the Criminal Justice Bill in relation to extending the ability to make public space protection orders to the police, in relation to extending closure order powers to registered providers. Currently, only the police and local authority can apply. There's a proposal to reduce the age at which you can be served a CPN, a community protection notice, to 10, as well as suggestion that dispersal powers ought to have the requirement for senior officer approval removed. I've mentioned the power of arrest changes and the proposals that there are there, and the changes to the Vagrancy Act. So there's a fair bit in there. I'm not sure how much value add that they're going to be if in reality, but it's worth just keeping an eye on what's in the pipeline, currently at report stage, as I say. Before I go, I'm going to thank both India and Sarah for their excellent talks, and remind you all that the slides will be sent to you. They'll also be available on our website, as will our recording of today's webinar. If you want to find out more about some of these provisions, there are 2 resources I'm going to flag, one of which is on there. My book, Cornerstone on Antisocial Behaviour, has a dedicated chapter on injunctions, including committals. And at the back, in the appendices, there is a list of suggested clauses for injunctions and the wording. They're starting points. They're not meant to be pick them off the shelf and be appropriate for all cases. They won't all suit all cases, but as a starting point for your drafting. But also in the near future is going to be a book specifically on gang injunctions that Sarah, Salmon and Jack Barber in Chambers have authored. So do look out for that. And if you do need any more information, or if you do have cases that are causing you sleepless nights or concerns, then you've got our contact details on this slide. We'd welcome instructions on any of the areas that we've talked about. And I hope that you found today's session useful. Thank you for joining us.